Good afternoon. Can I be heard?
Yes, you can be heard, Mr. Leventhal.
Oh, good. Thank you.
I ask you to keep your microphone on mute until you're ready to speak. Okay, good afternoon, everyone. Today is Thursday, November the 2nd, 2023, and the Board on Professional Responsibility is convened in the matter of Rudolph W. Giuliani, Board Docket Number 22-BD-027. Will the parties identify themselves for the record, please, starting with Disciplinary Counsel?
Hamilton Fox, the Office of Disciplinary Counsel.
Thank you, Mr. Fox. Respondents' Counsel?
John Leventhal, and right next to me is Barry Cammons, who will go on the video when the sanction section starts.
Okay, Mr. Leventhal, is that how you have decided to split your time? We're here on exceptions to the hearing committee report from respondent who will proceed first. You'll have 20 minutes, and I understand that you intend to share your time with Mr. Cammons?
Yes, if it would please the board, I would take 10 minutes on the merits. Mr. Cammons will take 7 minutes and will reserve 3 for rebuttal.
Okay, that sounds very good. So if you're ready, Mr. Leventhal, you can start whenever you're ready.
Thank you, Madam Chair, members of the board. As you know, my name is John Leventhal, and we represent the respondent, Rudolph Giuliani. Mr. Giuliani should not be disciplined, as the original complaint was superseded by the first amended complaint, and the second amended complaint was not permitted to be filed. As we noted in our reply brief, this issue was preserved in our opening statement and argued in our closing statement, contrary to what disciplinary counsel contends. So the only viable document before the Pennsylvania District Court was the first amended complaint, which Mr. Giuliani did not file. The board should take notice that the original complaint is deemed a nullity when it's replaced by the first amended complaint. An amended complaint supersedes an original complaint, and the original complaint is treated as being non-existent. Now, the second amendment...
Mr. Leventhal, now, what you said is correct in terms of the procedure. There was a complaint, first amended complaint, and then a proposed second amended complaint. But isn't it correct that Mr. Giuliani, that the respondent here proposed the second amended complaint to the court in a motion for leave to file it, which was based on the allegations in the second amended complaint?
That's correct, but that was not allowed to be filed. I guess an analogy would be on Rule 41 of the Federal Rules of Civil Procedure, someone could actually file a complaint and withdraw it before an answer is served or before summary judgment is served upon the plaintiff, and they could withdraw it without fear of discipline. Now, Mr. Fox and the disciplinary counsel say, "Oh, this shouldn't apply to a disciplinary," but that's simply not true. I mean, you have the safe harbor provision under Rule 11, where someone files a complaint and it may be, for argument's sake, frivolous, right? For argument's sake.
Right, but Mr. Leventhal, what would you say, because I want to tee up for you is that there was actually an active filing before the court, which was the motion for leave to file the second amended complaint. So, I mean, how would you respond if it was suggested that it doesn't help you that the second amended complaint was not accepted because there was a motion for leave to file that? And also, it's correct that respondent did argue before the court based on what was in the second amended complaint. So how would you respond to that?
He was really arguing the first amended complaint. That was the only paper before the court at the time that he appeared on the day that he was admitted pro hac vice. But how I would answer that is that the second amended complaint was without legal effect because it was not filed with leave of the court. And I cited case law for this. The failure to obtain leave results in amended complaint having no legal effect. Now, if it has no legal effect, then the fact that he attempted to file it is the same as in a Rule 41. It's filed and it's withdrawn, or on Rule 11, it's filed, someone brings sanctions, and that's withdrawn. So
But,
it has no
excuse me,
legal.
Mr. Leventhal, I understand that, but picking up on Ms. Sargent's point, 3.1 does not require the filing of a complaint for disciplinary counsel to make out a 3.1 violation. It merely says bring, defend, assert, or controvert an issue without basis in law or fact. So I understand your argument, but did he not bring, defend, assert, controverse an issue, even though even though the Second Amendment complaint was not allowed to be filed?
So are we talking about his argument before the court now, or are you talking about the actual complaint?
Talking about his argument before the court.
All right. Well, his argument before the court, I would explain it this way. You had Hicks, who was a seasoned attorney who argued Pierce versus Allegheny County on an equal protection ground, which he was successful in getting a limited injunction on a statewide Pennsylvania election. He chose 7 counties. You had Kearns, who came in and filed the First Amendment complaint. She changed that, took out a lot of the causes of action, but she also cited the same plaintiffs and the same counties. So when Mr. Giuliani comes in on November 17th, after being admitted pro hac vice, he's kind of stuck with the plaintiffs and the defendants. And what Mr. Fox and disciplinary counsel are saying is that he couldn't get the relief from suing those 7 counties. And maybe I would agree with that, but who is that hurting? It's a disservice against Mr. Trump, not frivolous, because if he sued all the counties, you would have the notice to cure of that 10,000 that was not allowed to be, that was allowed to be cured. And if you have the rest of the state, you don't know how many were not allowed to be cured, and that could have been 80,000. So his argument, he was stuck with the argument that was handed down to him by Hicks and Kearns with the 7 defendants and the same plaintiffs. So he couldn't change that. He couldn't change that coming in on November 17th.
Excuse me, didn't your client coming in that way, as you describe, have his own and independent responsibility to review the factual basis on which the matter was proceeding? And on, what choice did he have? If there was no sufficient factual basis to bring the proceeding, he could have chosen not to bring the proceeding if it was based on speculation. And that appears to be what you're saying. It could have been this, it could have been that.
Oh, no, I'm not saying that. I'm saying
could he not have made an independent ethical decision as to how to proceed?
Well, hindsight is 20/20. But I have to tell you that he comes in on the last day when, you know the history. I don't want to go through it. You had Hicks, you had Kearns, you had other attorneys, you had Skorinsky and him come in on November 17th and ask for an adjournment, where maybe he would have looked at all of this, and maybe he would have reconsidered. I don't know, but an adjournment was denied, and he came in and he was handed this. The second amended complaint is pretty much like the original complaint, and he had to argue it.
This appears to be a variation of a quote time pressure unquote argument that there was
an election law also,
that there was a collapsed period of time, an urgency here to file this. So suppose the time pressure had not been a factor, as you're describing. Are you saying that a complaint, or are you conceding that a complaint filed then without this supposed time pressure on the same factual basis or lack thereof, as was present in the matter before us, are you conceding that that would have been frivolous if there hadn't been the time pressure?
I don't think I have to make that concession, but I just want to say something to you, that he was criticized about doing the observational barriers. Now, I cited to you a case of Vaughn versus Collins, which was a Fifth Circuit Court of Appeals case, which basically you had a Caucasian bringing a Voting Rights Act action, and they were sought to be sanctioned. And they said, well, this is unprecedented. So, and there's no precedent in the circuit to do that. It's a novel issue. I think from him arguing the observational barriers, that no one could see it in violation of Pennsylvania law, where someone had to be present when the ballots were opened, counted, and recorded. And he was saying that all those ballots that couldn't be observed should be thrown out is a novel argument. I'm not saying.
Mr. Leventhal, it's not so much a question of argument, what you're going to argue. The question for Rule 3.1, it's not just argument, but what your evidence is. And the finding of the hearing committee was that there was no evidence pled or presented that would have supported the relief sought or the claim that these errors, alleged errors, affected the outcome of the election, such
Well,
that the relief sought was correct. So are you conceding that Mr. Giuliani might have had a novel argument, but actually had no facts to back it up?
Well, he had the facts about the observational barriers, number one. Number two, he had 240 or 250 declarations which were not introduced. And I just want to point out that Mr. Fox is probably going to make the argument, number one, that was, I'm sorry, the ad hoc committee said it was given at the last minute. It was given in August of 2021, those declarations, not at the last minute. I want to correct that. And also, that Mr. Fox was saying he began preparing to file litigation on behalf of the Trump campaign on the day after the election, when the hearing committee basically said it was only after he received the phone call about the observational barriers in Philadelphia. So what I am saying is, if Mr. Hicks had sued all the counties in Pennsylvania on the notice to cure, that was potentially a winning argument, because you have the 10,000 where notice to cure was allowed, and you have the rest of the state where it wasn't allowed. And if you could find out how many people were not allowed to cure their ballots in the rest of the state, then you might have had 80,000. The problem that they made was not citing all of the counties in the state. And that was not Mr. Giuliani's mistake. That was Mr. Hicks, and it was reiterated by Ms. Kearns on the First Amendment complaint.
And
Mr. Leventhal.
Go ahead. I'm sorry, Ms. Cassidy.
Mr. Leventhal, so are you saying that the issue is that that notice and cure was not allowed, or is your position that notice and cure was allowed, but it wasn't being consistently filed across the Commonwealth? And for either of those positions that you're taking, what was the factual evidence in the legal support that respondent was able to put forward to support either of those positions?
Well, he put forward that notice of cure was allowed in Allegheny and Philadelphia and the 5 other counties. Now, he also alleged, and there were affidavits, that notice of cure was not allowed in many of the other counties. And if you really, and I don't see, when reading on, if you look at our exhibit 20 on page 20, I would say a reasoned interpretation of Pennsylvania versus Bookvar could only be implemented by the notice and cure procedure could only be implemented by the Pennsylvania legislature. Let me quote, if I may, and I quote in part: "The extent that a voter is at risk for having his or her ballot rejected due to minor errors made in contravention of those requirements, we agree that the decision to provide a notice and opportunity to cure procedure to alleviate that risk is one best suited for the legislature." The opinion goes on to state, "We express this agreement particularly in light of the open policy questions attendant to that decision, including what the precise contours of the procedure would be, how the concomitant burdens would be addressed, and how the procedure would impact the confidentiality and counting of ballots, all of which are best left to the legislative branch of Pennsylvania's government. It is clear that the court was alerting the parties to the appeal that there should be one procedure and only if enacted by the legislature. Different procedures in different counties for counting ballots would be violative of equal protection under all the relevant case law.
Mr.
And
Leventhal,
even now-
Mr. Leventhal, I'm sorry to interrupt you. Well, Mr.
Of course you can.
Gilbertson, you have a
That's
question.
your
You go
job.
ahead. Let me.
If that's the outcome, Mr. Leventhal, then he may have an argument to toss out the ballots that were allowed to be cured. But how could we then add in the ballots that were not allowed to be cured? Because at the end of the day, what you're arguing is the treatment needs to be uniform across the state and all of the across the Commonwealth and all of the counties.
Well, as I said, that was Hicks's problem, that was Kearns's problem, and that was inherited by Mr. Giuliani.
The math doesn't work.
Excuse me?
The math doesn't, there's no logic to it.
Well, no, sir, Mr. Gilbertson, assuming arguendo that they sued all of the counties in the state, you would have the ones that allowed notice to cure and the ones that didn't allow notice to cure. And if they were going to all allow notice to cure, then the election might have been different.
Yeah, you know what, Mr. Leventhal, you're making arguments here on your notice and cure, which is probably your strongest point. But we keep coming back to this basic issue. Argument is not evidence. And to file a complaint, you have to have some degree of proffered evidence, some facts that you allege that support the claim and the relief sought. So, go ahead.
He wasn't able to ferret out, obviously, the counties that weren't sued at that point. So what was he to do to come in at the 11th hour? I mean, we're putting this onus on Mr. Giuliani, who comes in on the 17th. And his contribution was he wanted to have the same type of argument throughout the country that people weren't allowed to be observed. That was his contribution. He didn't pick the 7 counties. He didn't pick the plaintiffs. That was his contribution to this. That was clear.
Mr. Leventhal, then if that, so two things here. If that was his contribution, if he was worried about the observational barriers, and as you're suggesting, and correct me if I'm wrong, that he inherited the arguably, this is what I'm hearing from you, unsupported notice, factually unsupported and legally unsupported notice and cure argument, should then not the responsible objective lawyer then get rid of the notice and cure and stand forward on his observational barriers, especially if that was his strategy and that is what he was contributing, combined with the fact that arguably he didn't have the facts or the law for the notice and cure?
Let me say this. I figured this out only recently, what the problem was with the not suing all the counties. He comes in at the last minute. You know, as I said, hindsight is 20/20, but also the observational barriers, whether you agree with it or not, it's a novel issue. It was the Pennsylvania statute is 25 PS section 3146.8B, which says the ballots have to be, the watches have to be present when the ballots are open, counted, and recorded. Now, there was a big dispute about that. You were in the room, that's good enough. There was conversation. So he's arguing basically a novel issue that all those ballots that couldn't be observed when counted should be disallowed. Now, you may disagree with that. And you may, and that is supported by his theory, and that's supported in the record. You may disagree with that, but I don't think that's frivolous. That's a novel, unique argument in an unprecedented election when you had 2,650,000 absentee ballots in Pennsylvania alone, which is 900% greater than in the 2060 election.
Mr. Leventhal, I don't want to beat this to death, but argument is not enough alone. An argument's
No,
not.
but that was substantiated, that people could not observe the counting of the ballots. That was substantiated, number one. And number two, look, we know what's going on in the world today. It's absolutely crazy. But in a country which may be run by, and I'm not comparing that to the United States, where the United States would be monitoring an election, we wouldn't stand for it if people couldn't observe the counting of the ballots.
Mr. Leventhal, then tie that to the relief that was requested by the respondent and give us the logical, legal, factual basis for tying the relief he requested to the observational barrier claim that he was raising.
Well, the first relief he asked in the TRO is to don't certify the results at this point until we can have a more fulsome exploration, maybe in discovery, to find out what went on here. He wanted to slow everything down.
Is it all right to file a complaint that's not supported by facts so that you can get discovery to find facts?
Well, again, on the observational, I think he had the facts on the observational barriers. And maybe the court would have given him, maybe the court, I'm sorry, I couldn't hear you, sir.
I don't think the hearing committee found that he had the facts on that. I mean, if you look at the hearing committee's findings of fact, here's finding of fact 40. Although the materials that your client relied on identify a handful of isolated election irregularities, they completely failed to demonstrate that the observational boundaries or notice and cure procedures facilitated any meaningful fraud or misconduct that could have possibly affected the outcome of the presidential election. We've got to deal with the hearing committee's findings of fact. And it strikes me from that those findings of fact are contrary to your assertion that with respect to observational boundaries, that he had the factual basis to bring a claim on that basis.
Well, I'd also like to note that on the same day that he argued, that's the day the Pennsylvania Supreme Court held that the observational barriers did not violate the election code in rate canvassing at 241 Atlantic 3rd, 339 at 351. So he was not aware that they were saying that was okay at that particular point. But I do think that an argument can be made that if people could not observe, they didn't say that people could observe the ballots. What the Supreme Court did with Mr. Mercer, they said that, being in the room is good enough. And 3 judges, or at least 2 judges, dissented, and they say that's not meaningful observation. So I don't see how we could say that Mr. Giuliani was frivolous in raising the fact that if there's no meaningful observation, those ballots shouldn't be counted. If you and I were in a third world country and we were picked as observers to watch the election, they wouldn't let you watch the opening, the counting, and the recording of the ballots.
Mr. Leventhal, you all made that argument in your brief, and we're not talking here about election monitors. We're talking about observers who are this is the state of the Pennsylvania law. They're in the room to just generally observe the canvassing and separation of absentee ballots. So I don't know how that argument about election observers or monitors really advances anything. So what I'm going to do now.
Could I just finish up with one short thing?
Please do.
I put this in my brief also, but I just want to bring this to you. I cited the Wisconsin Supreme Court case, Wisconsin Voters Alliance versus the Wisconsin Election Commission, where the petitioners, similar to the plaintiffs in this matter, sought a declaration that the 2020 presidential election in Wisconsin was null and void. They sought an injunction enjoining the certification of the election. And the 3-judge minority of the Wisconsin Supreme Court noted, historically, we often do not provide all the relief requested because the ad hoc committee really tore into Mr. Giuliani about asking for the relief that he asked for. The minority also noted, excuse me? The minority also noted with apparent approval that one form of relief sought by the petitioners is any other relief the court deems appropriate. Likewise, we emphasize that one form of relief sought by plaintiffs in the federal court litigation was any and such other further relief that this court deems equitable and just, or to which plaintiffs might be entitled. And I just want to say one last thing. In Iqbal and Twombly, usually if it's not substantiated, it's dismissed. Very few people, if then very get disciplined for not supporting their complaint. It's just dismissed. Thank you very much.
Mr. Leventhal, before you sit, I'm just going to make sure that no other board members have questions. Mr. Hora, do you have any questions? Ms.
I'm going to stay,
Blumenthal?
but I'm going to slide over for Mr. Kamens.
Well, stay here just in case if someone has a question.
Okay.
Yeah. Ms. Blumenthal, do you have any questions? No. Ms. Cassidy? Mr. Walker? Mr. Gilbertson, do you have any more questions?
Very quickly, and it's on that last point that you made, Mr. Leventhal. If I seek leave to file an amended complaint and there's a finding of futility, and that's what happened here, right? The Middle District of Pennsylvania found that the second amended complaint that the respondent was seeking leave to file would have been futile. And then that's a finding that was upheld by the Third Circuit. And one thing I was interested in hearing from you about is, what's the difference between something that's going to be futile and frivolous?
Well, as I said, he shouldn't be disciplined for the second amended complaint. And the district and the grievance committee is not seeking to discipline him on the Third Circuit. I'm sorry.
The court did not seek to sanction him, right?
Right, but also the complaint was not accepted to be filed, and I cited case law, and I would take issue with disciplinary counsel saying, although that's the rule in the federal rules of civil procedure and that's the case law, it shouldn't apply to disciplinary. I would disagree.
I guess that gets to the nub of my question, because you've made the point, and I hear it. It's kind of like the dog that didn't bark. Neither the Middle District of Pennsylvania nor the Third Circuit sought to sanction the respondent for seeking leave to file that second amended complaint. And they could have, right? They could have, but they did not. But the fact that they could have, I think, cuts against your argument that it's just a dead letter and it's a nullity and it's not something that we can address under our rules.
If I may, Judge, if I may respond to you more fully, Judge Brand basically said that it would delay things. The Third Circuit, although they talk about futility, that was dicta. They basically said Judge Brand was right, it would delay things, and they're not allowing it. So that was really dicta. And that was the basis for the dismissal. And I submit to you that Judge Brand, even though people could have made a Rule 11 application, the adversaries didn't make that application. And Judge Brand could have done it himself, sua sponte. He didn't do that. And I want to thank you for your time and thank you for listening to me. And I will shove over.
Good afternoon to members of the board. May I begin?
Just a second, Mr. Kamens. I'm sorry. I meant to finish my survey of the board members to see.
I'm sorry.
I'm sorry. It's not your fault. Mr. Hindle, do you have any questions for Mr. Leventhal?
No.
Ms. Rice Hicks?
Yes,
No.
I do.
I'll be right back. Hold on, give me a second.
Yeah, it's my apology. I think I had myself on mute.
No, it's all right. How are you?
Brief. I'm fine. How are you? I just have a brief question
Sure.
regarding the uncured ballots. Trying to understand your position. How could the uncured ballots have changed the results of the election if respondent did not request that defective ballots be allowed to be cured?
And I'm agreeing with you that Mr. Hicks and Ms. Kearns did not sue all the counties that were needed to give full relief. And I'm saying that Mr. Giuliani coming in on November 17th to argue could not change the defendants at that late date and add all the other counties.
Okay, so then are you arguing that the Second Amendment complaint should have included a claim to count the uncured ballots? And if
That's
so,
right.
if so, why should we consider arguments not made in the underlying litigation when assessing whether disciplinary counsel has carried its burden?
Because I'm saying to you that what had happened was a disservice to the client. It wasn't a frivolous lawsuit. They hurt their own client by not suing the other counties. If they sued all the other counties, they might have gotten relief. If anything, there was kind of a malpractice by Mr. Hicks and Kearns, and Mr. Giuliani had to adopt that because he's coming in on the morning of the argument. I agree with you. To get full relief, they should have sued everyone, but it's not frivolous.
Thank you.
Thank you, Ms. Rice-Hicks.
Mr. Tiger, and
I'm
we're
not
finally at
moving.
the end.
I'm
No,
not moving.
we're finally at the end. T for Tiger. Mr. Tiger, do you have any questions for Mr.
Yes,
Leventhal?
just one. Judge Leventhal, you make much of the fact that the court would not allow the Second Amendment complaint to be filed. But under these circumstances, why does that make a difference? Because why isn't it like the situation of a guy that gets tooled up with armed and he's on his way to stick up the bank, but he gets run over at an intersection? He still shows all of the indications that he's prepared to commit a wrong that the society can take note of.
Mr. Tiger,
I'm sure
the only way
had cases like that.
I'm not going to go into the criminal law analogy, but I am going to answer it this way. Rule 41 of the Federal Rules of Civil Procedure allows someone who may make, and I'm not agreeing that the complaint is frivolous, right? But for argument's sake, someone files a frivolous complaint, and before the answer, it's still filed, it's still in the court, it's still out there. It might be out there for 20 days. This was only out there for less than 1 day. But let's say it's out there for 20 days, and before an answer is served, or before a motion for summary judgment, that can be withdrawn, and there would be no discipline. Similarly, in Rule 11, someone files a frivolous complaint, and it's out there, and it's being argued, and someone makes a Rule 11 sanctions application, and the person within the safe harbor time period withdraws it, there'll be no discipline. And this is the analogy that I'm saying. He brings it, it's there for less than 1 day, it's not allowed to be filed, it should not be disciplined. And that's the answer I'm giving you, Mr. Tiger.
All right, thank you, Mr. Leventhal. Thanks for your patience too. With the,
No, thank you, and thank you for hearing me and giving me extra time.
Okay, good afternoon to members of the board. The respondent takes exception to the committee's recommendation that respondent be disbarred. In the event that this board finds that rules 3.1 and 8.42 were violated, it should impose a sanction less than disbarment and one that is appropriate based on the record before the committee below. It is our position that the ad hoc committee has failed to give sufficient weight to certain mitigating factors that should be considered in a more favorable light by this board. First, the respondent's record of public service. The respondent has given the people of New York City and
Mr. Kamens, I'm sorry to interrupt you so early, and you're going into a really, important part of your argument on sanction is Respondent Giuliani's prior public service and his record. But can I ask you, how would you respond to the assertion that, in fact, his status, the fact that he was nationally known, he was associated with a terrible attack on the United States, and his handling of that as the mayor of New York in the aftermath, don't you think the status of who Respondent Giuliani was influenced how his assertions, he was able to translate his reputation into credibility for these assertions, that on balance, the hearing committee found, and the courts that considered it found, he had no factual support for. So should we look, how would you respond to that? Should we look at that? Should we look at the fact that his reputation and his accomplishments allowed him to exploit a frivolous lawsuit?
Certainly,
Go ahead.
certainly his background as a public servant should not have allowed him to exploit anything. But our position is that he was an attorney representing a client whom he believed in, and a course of action that he believed in. And yes, the facts, if you find the facts were insufficient, so be it. But he was an attorney representing a client, and this was his best efforts under the at the 11th hour, as Mr. Leventhal has said repeatedly, to represent a client as in the best light possible. And let me just go back to his public service. The problem here is that we all talk about his public service, but disciplinary council has effectively dismissed it and as being irrelevant. And while the committee stated that it considered, those were its words, his public service, nonetheless, it found that it happened a long ago, and that his misconduct transcends all his past accomplishments. I think it's troubling that the committee has chosen to essentially discard this stellar record of public service that's really been unmatched by most public figures. Just as 9/11 can never be relegated to the dustbin of history, Mr. Giuliani's achievements can never be forgotten, and they should be given due consideration by the board. Equally troubling is the committee's comment that respondents' past accomplishments are essentially negated by his misconduct. And in evaluating an attorney's misconduct, it seems clear to us that one's good deeds must be weighed against his misdeeds, but not canceled out completely. And what were those good deeds? As a prosecutor, he litigated thousands of cases, most notably 300 to 400 members of the Italian-American Mafia, 800 members of the Sicilian Mafia. He prosecuted 2 former Nazis responsible for—
Mr. Kamens, sorry to interrupt you on that. Can you respond for us to the argument that disciplinary council makes is for sanctions, and the hearing committee seemed to have bought into, which is that Mr. Giuliani, through his actions in Pennsylvania, had the effect of causing instability in the nation related to our election system, and the fact that that alone should carry the weight of a sanction of him losing his license. Can you address that argument that disciplinary council puts forward and that the hearing committee adopted?
Disciplinary council's argument is that Mr. Giuliani was undermining democracy. Our position is that Mr. Giuliani was in court representing a client, making the best arguments he could in the light most favorable to his client at the time. If this board finds that his efforts were insufficient—
Mr. Kamens, let me interrupt you again there. I appreciate that, him being a lawyer representing a client in a courtroom making his best arguments. However, the gravamen of his complaint was not a personal injury suit. The gravamen of his complaint was not a contractual breach. The gravamen of his complaint, in its essence, was that our election system and our democracy was being undermined because there was improper voting. And ODC uses that to make the argument successfully that therefore he should lose his law license. So please address the gravamen of his complaint related to his sanction, not as if this were some case that was a contract breach or plaintiff's personal injury.
Well, the first thing that comes to mind is the fact that, there were certain members of Congress that filed a lawsuit against respondent and others, claiming that he and others conspired to prevent members of Congress by force, intimidation, and threats from discharging their duties. That was an allegation that was also made against respondent. And on February 18th of 2022, Judge Ahmed Mehta of the U.S. District Court of the District of Columbia dismissed the complaint, saying that plaintiffs did not plausibly establish that he conspired to prevent them from performing their duties. Our position is that he had no intent to go into court and destabilize democracy or to create uncertainty in the election process or across the nation. This is a 3.1 rule violation, and he's being charged with that. He's not being charged for undermining democracy. He's being charged with a discrete violation of the disciplinary rules, and we're saying that his conduct, while if he's found in violation, should not, under the facts here, warrant disbarment. And if I could just go back and just continue with some of the, I mean, his public service was, as I think we all agree, was three decades of his life was spent in service of this country and the city.
I think you've already addressed.
I'm sorry?
You've already addressed the public service aspect of your argument. Is there anything in particular, or can you, you're running out of time here. I think we got it. Is there anything else that you want to address before your time?
Yes. And this, well, if I could, I understand, I appreciate that. Thank you for some extra time. And the seriousness, in assessing the seriousness of respondents' ethical violations, disciplinary counsel unfairly compares respondent to an attorney by the name of Teresa Squillicoat. And Ms. Squillicoat was an attorney subsequently disbarred who was convicted of espionage by spying on behalf of the Soviet Union. And counsel argues that both Squillicoat and Mr. Giuliani quote, betrayed their country. And the comparison, in our opinion, is ludicrous. Respondent was an attorney representing a client. So
Mr. Kamens, let me ask you this, because it seems to me that you're saying that the board should not look at facts that are frankly in the record here and in the public domain, which is, it's not just a lawyer representing a client. Here, respondent Giuliani was associated with the defeated candidate, Donald Trump.
Yes,
and he was, publicly and vociferously an advocate for him during the campaign and afterward. And I do believe, I haven't actually reviewed the transcript, but I believe he did testify that this Pennsylvania case was part of a strategy to bundle together about 10 cases to bring to the Supreme Court with the aim of revisiting the results of the presidential election in 2020. So this was not just a case, but a movement case. And should the board consider that or not? And which way does it count? Is it in an odd way? You can almost say that it was a case like, an early case that was meant to be a test case to advance certain civil rights causes. We'll do this small case and it'll go on. Only this was a big case, and they were hoping to bundle it for 10 to the Supreme Court. Should the board be able to look at that? Why or why not? And how does it cut for your client?
Well, all I can respond to is by saying, don't we want to encourage people to air their grievances in court, no matter how novel or how unprecedented, even if these grievances are ultimately rejected, so that the issues can be vetted within the court system rather than through other less desirable means? Was it undermining democracy for a respondent to go to court, file papers, and try to utilize the court system to advance arguments on behalf of his client and to raise some arguments that the committee found not to be frivolous? And while the arguments raised on behalf of a client were ultimately rejected, is he to be disbarred for availing himself and his client of a lawful process by which he could raise these issues? And I know my time is it's over. If I just have another minute.
Yes, Mr. Kamens, you can have a minute, and then I am going to survey the other members of the board to make sure they don't have questions for you. But please take another minute.
All right, thank you. We also, and this is the collapse time argument I think that Mr. Walker was referring to. We strongly disagree with the committee's rejection of respondent's argument that he did not have time to fully investigate his case before filing it, which undoubtedly obviously contributed to the nature of the facts asserted. The committee failed to sufficiently credit the predicament that he was in, that Mr. Leventhal has gone over a number of times, coming in at the 11th hour. And finally, we'd like to ask the board to consider that under Rule 3.1, which respondent is charged with violating, the comment to the rule provides in part as follows, quote, the filing of an action or defense for a client is not frivolous merely because the facts have not first been fully substantiated or because the lawyer expects to develop vital evidence only by discovery. And further, it says such action is not frivolous, even though the lawyer believes that the client's position ultimately will not prevail. Thank you very much.
Okay, Mr. Hoare, do you have any more questions for Mr. Kamens? Ms. Blumenthal, do you have any questions for Mr. Kamens? Ms. Cassidy, do you have any more questions for Mr. Kamens? Mr. Walker, do you have any questions? Mr. Gilbertson?
Mr. Kamens, in your brief, you argued that, and you urged us to keep politics out of this, right? Were the words you used. And there's been some of that in your argument today, although I'm curious, which way that would cut here, because, political speech is entitled to the highest form of protection there is under the First Amendment and under the litigation privilege for that matter. And this kind of goes to the question that Ms. Sargent was asking you. There's some testimony in the record about what Mr. Giuliani and his clients' ultimate aims were. And then there's some, there's a great deal of public information that's out there. But what is it, and she asked you this, I'm not sure I heard an answer. What is it that you contend the hearing committee was allowed to consider, not in assessing the respondent's liability under the charges, but sanction? Because typically under sanction, we're allowed to consider the larger milieu against which the charged violations occurred. And so what is your position on what was in the record, what was not in the record, what was fair game for the hearing committee to consider, and what was not? Well, and can we really keep politics out of this?
Well, respectfully, I didn't raise the political issues. I think I was being asked to look at the larger political issues and answer the question. I think politics cannot be a part of this calculus. I think Mr. Giuliani is being charged with a rule, and he should be disciplined according to whether he violated the rule or not and mitigating circumstances. But I certainly think political issues should be kept out of this.
Mr. Hindle, do you have any questions for Mr. Kamens? Ms. Rice Hicks?
No.
Mr. Tiger?
Yes, it is certainly true that Mr. Giuliani has an impressive record of public service. He was the United States Attorney presiding over the largest U.S. Attorney's office in the United States. But in that capacity, he had to make difficult decisions every day based on questionable facts. He comes to us not as someone with relative lack of experience who perhaps can be excused for, being in a predicament that you described. But doesn't his record of discernment, of considering the social implications of cases he brought, such as some of those mafia cases, doesn't that cut against him when it comes to assessing a sanction?
Not when he had, I'm sorry.
No, Judge, and Judge, what do you think?
Well, he certainly, as the chief prosecutor in the Southern District, he certainly had the time to take all the time he made to take before making those decisions. I don't think he was in the same position. He wasn't under the pressure that he was in this case. In this case, he was under tremendous pressure coming in and I won't go over the facts. So I think that he had the luxury of making the decisions he made as the U.S. attorney that he didn't have in this case.
All right, so Mr. Kamens and Mr. Leventhal, you each reserved 3 minutes in rebuttal, and we'll go to disciplinary counsel now. Mr. Fox?
Thank you. Members of the board, I want to turn first to the question of whether there was any factual basis for this complaint. But before this case, and I almost lapsed into the mistake that I was going to try to correct, which, as Ms. Cassidy pointed out, that the Rule 3.1 doesn't simply prevent you from filing a frivolous complaint. It prevents you from advocating frivolous issues. And that's exactly what Mr. Giuliani did here. I'll turn in a minute to this argument that he came at the last minute, but I want to go to the introduction of his oral argument in front of Judge Bram the oral argument in the case. It's on page 15. It's our Exhibit 8. And this is what he says by way of introduction. But the best description of this situation is it's widespread, nationwide voter fraud, of which this is a part. And that's probably the reason I'm here, Your Honor, because this is not an isolated case. It's a case that is repeated in at least 10 other jurisdictions. That was what he was arguing to the district court judge, that it was widespread voter fraud. Now, the notion that he came in at the last minute and was forced to make this argument is ludicrous. He didn't come into the last minute. The day after the election, which was November 4, he started this process. He testified to that. His name isn't on the initial complaint because he wasn't a member of the Middle District Bar at the time, but he testified that he participated in drafting that complaint, and he made that argument, and his argument was fraud. So the notion that he somehow or other was compelled to make this argument, and that Mr. Hicks made all these mistakes, and which is not Mr. Giuliani never testified to, but
Mr. Fox, you hit on a word that's going to tie me into the sanctions argument. You said that Mr. Giuliani went into court and made a fraudulent representation to the court. I heard you use the word fraud. So if your argument to get him to disbarment, or your position today is that he was engaging in untruths or fraudulent behavior, why is it not that we did not see that in the initial complaint? And given that it was not in the complaint against respondent, how is it now that you can use it in your sanctions as if it were part of the complaint against Mr. Giuliani?
I did not say a moment ago that he made a fraudulent argument. What I said was that he argued fraud. He argued election fraud to the court. And I don't think we have said at any place in our brief that he committed fraud in the argument. I think we said that he made arguments for which there was no factual support, but I don't think we've ever charged him with defrauding the court. And that was not the point that I meant to make. What I was trying to make, and I guess I was unclear, what I was trying to make is that from the start, he's arguing to the judge that this is election fraud. That's what we're dealing with here. And yet never once, the election fraud somehow came out of these observational barriers, which were necessary because of the pandemic. Never once did he show how any fraud that had been committed because of the electional barriers. Nothing. There's no evidence of it whatsoever. Now, Mr. Leventhal said, well, he made a novel argument. There was a novel argument that these barriers violated Pennsylvania law. That's not a federal issue. That's not election fraud. That's not a 1973 case that he's bringing. And that wasn't a novel argument he was making. His argument was that these barriers caused or permitted election fraud. Now, in any case like this, I was in the situation of trying to prove the negative. So how do we prove the negative? We got every single document from every single law firm that was involved in the case on the plaintiff's side, and we put them into the record. Mr. Giuliani, I think, produced 625 pages of documents. One of them was the Mercer affidavit that one of the lawyers alluded to a moment ago. The Mercer affidavit is an affidavit of a lawyer, a man who, and it was a lawyer, who said he couldn't see and had some problems. Mr. Giuliani cites this as evidence of election fraud. The Pennsylvania Supreme Court cited the Mercer document as evidence that he had sufficient, the same affidavit, that he had sufficient observational ability under the Pennsylvania law. There was no evidence of election fraud. In the various complaints that were filed, there were 26 specific factual allegations that Mr. Giuliani said amounted to election fraud. In our, Ms. Rice-Hicks has a question for me, I think.
Yes, thank you.
So in regards to your, you're speaking about what Giuliani statements he made before Judge Brand. It also seems that the hearing committee concluded that respondents' claims of election fraud were not intentionally false, but were reckless because he did not have evidence to support those claims. Can you point to evidence in the record that you're speaking about that supports the conclusion that he consciously disregarded the risk that he was making false statements to Judge Brand about the election?
Okay, again, we haven't ever claimed that he made false statements. What we claim is he made unsupported statements.
So, Mr. Fox, just to follow on a little bit with where I think Ms. Rice-Hicks and I might be thinking similar things, maybe Ms. Cassidy too. We're not saying that you made that as a charge or an argument, but to get to the sanction, is the question of whether Respondent Giuliani made recklessly false, unsupported statements in his arguments. Does that impact sanction at all? I know we're jumping ahead, and I don't want to foreclose you going through the facts, but is that something that factored into the sanction at all?
It factored into the sanction in this way, and in a way that I think is entirely appropriate. And then there's, I think, 7 traditional factors that are taken into consideration to sanction. One of them is dishonesty. And what the hearing committee said was, well, he wasn't dishonest in the sense that he didn't make any false statements. Nobody's accusing of that. But they said that his and I think I'm close to quoting this, his hyperbolic claims were the claims of election fraud were utterly false and recklessly so. So what they found that was false was the claims that he made of election fraud, not the facts, but the claims that he made. And the point that I was making a moment ago about the facts is that we got our arms around all of the facts, and they just don't support the claims. What they support is what the hearing committee found, that they were hyperbolic and they did not support the claims. And that's the point here. And where I was trying to go was we tried.
Mr. Fox.
Yeah.
Mr. Fox, before you go further, let's take as read your characterization of the evidence. But at page 26 of your brief, you say that Mr. Giuliani committed an admission of a conspiracy to undermine the results of the election and of democracy. Now, conspiracy is the paradigmatic specific intent crime. That is to say, the conspirator has to know and has to specifically intend the undesirable consequence, which you characterize as being undermining our entire democracy. So where are the allegations that you made that would lay the basis for putting the evidence in? And what is the evidence that permits you to take the step from hyperbole and recklessness to this desire to undermine and overthrow?
Okay. I have the complicated answer to that. First, that arises out of something that came in the oral argument in front of the hearing committee. And Mr. Giuliani had said that there was a conspiracy, a nationwide conspiracy, along the lines of the quotation I just read to you, of people to fix this election. And my response to that was that if there was a conspiracy, it was a civil conspiracy, not a criminal conspiracy, and that it was a conspiracy to overturn the election or to challenge the election to undermine democracy with no basis to doing so. And what I cited for that was Mr. Giuliani's testimony. And his testimony was that the day after the election, the president asked him to put together a team, and that he started putting together a team to challenge the results in at least 10 different states. And he didn't testify to this, but he couldn't possibly have had any evidence of it at the time. And that's what I was talking about in the context of a conspiracy. He put together a group of people to get together to challenge these elections when he didn't have the factual basis for it. And let me remind you of something. The day after the election was November 4. If you'll remember, the case that the news media, the state that the news media cited for putting Biden over the top was Pennsylvania. And if you'll remember, it happened around noon on the Saturday after the election. So nobody was even sure which way Pennsylvania was going. And Mr. Giuliani is starting on the 4th. And as I said, the notion he just came in the 17th is baloney.
Mr. Walker has a question.
Oh, I'm sorry, Mr. Walker.
Sorry to interrupt.
Fox, do we have to find or agree with your notion or what you just said about Mr. Giuliani's participation in an alleged conspiracy to get to the sanction of disbarment? Because it seems from your complaint that stated context of a conspiracy and Mr. Giuliani's alleged participation in it is key to your seeking and asking for disbarment.
Well, again, I think there's a complicated answer to that. I certainly think that you can find that there was a conspiracy based on the evidence. We didn't charge him with this, but this came out of his own testimony. You know, and as you know, we frequently find out things in these hearings when that testimony comes out. But I don't think it's essential that you find that. I mean, I think if you just focus on what he was trying to do in Pennsylvania, you know, to undermine the will of the voters, to throw out, and I was going to get to these numbers in a minute, but I think the best number is 1.3 million votes. In a refusal to accept the results of an election for which he had no evidentiary basis there was fraud. I think that is sufficient in and of itself, regardless of whether it was part of a larger conspiracy. And
Mr. Fox, I'm going to go back sort of to my initial question.
Sure.
If that's your position, I mean, I understand that respondents often share something in the hearing that you were unaware of, but that doesn't seem to be the case here of what you're saying. You seem to be referring to facts that started occurring the day after the election and then leading up to when this complaint and when Mr. Giuliani argued in the courtroom. And you're using words like undermining the will of the voters, fraudulent representations or fraudulent claims about you know, votes being improper and votes being thrown out, and this sort of language here. So if that's the fact of what a lawyer is alleged to have done starting the day after the election, my question again is not, should we not see something more than a 3.1 violation?
Well, I'm not sure what particular violation that you have in mind. I mean, I'm limited to the rules that I have, and I think that's a good thing. I'm not a knight errant out to right all wrongs, and I don't have the authority to do that. Nor does this board, nor the court. I'm not sure what else we should have charged him with, but I don't think there's any issue here that he wasn't put on notice. I mean, he was given the facts on which we relied. He was given the violations that we charged. I don't think there's any due process issue here. I think the only issue here is whether the consequences of this misconduct were so unique, so severe, so grievous that they justify the sanction of disbarment, which I believe that they do. And obviously, the board is obviously much more interested in that. So I'm going to, unless you have any questions about it, jump to that rather than spend my time on the factual inadequacies of his arguments. Although obviously I'll answer any questions that you would like. Just to make one little point.
Mr. Fox, Mr. Walker has a question.
I'm sorry.
Yes, as we do this, Mr. Fox, to also include and address, suppose the board were to find the violations alleged or to agree with the hearing committee with respect to their conclusions on the violations, but suppose the board were to not find that supported disbarment. I'd like you to also address what an alternative sanction might be, not to argue against yourself, but to perhaps enlighten us.
I anticipated that question, Mr. Walker, and I know I had an exchange with Mr. Hora in an earlier argument in which I sort of said that I always try to answer the questions of the board. And what I decided was that I was not going to prepare myself to answer that question, because I think that's so wrongheaded that that a sanction less than disbarment for this kind of misconduct would be virtually meaningless. I mean, and maybe this is actually a good way to end. I mean, he's utterly unrepentant. We've got another election coming up. Lawyers need to be deterred from engaging this kind of
I think Mr. Fox might have frozen.
some lawyer himself. But
And I didn't do it.
Mr. Fox, we missed some of what you said because you froze for a while.
oh,
Yeah.
And
but did you get to the part where I was refusing to answer your question?
I got to the part
You
where
had mentioned deter.
headed.
Yeah, we heard up until the part where you were talking about we have a new election coming up.
Well, okay, yeah, I mean, and it is necessary, it seems to me, to defer lawyers from engaging this kind of conduct.
But
And
Mr. Fox, just on that point, it could easily, oh God, I hope it's not going to be easily, but it could in theory be the other way. You could have someone who's able to file a complaint supported by facts, maybe an informant, maybe leaked notes, maybe a recording of a meeting with planning of election fraud, and a basis to go into court with a TRO asking for the same kind of relief, maybe, and with a stronger factual premise. Do we want to chill that kind of conduct? Do we want to make lawyers afraid to argue tough cases, to stick their necks out with enough good faith basis in compliance with Rule 11 requirements? Do we really want to chill lawyers from taking tough positions and making novel arguments?
Of course not. And I recognize that there's an inherent tension between the lawyer's responsibility to zealously advocate for his client and a lawyer's obligation not to bring frivolous lawsuits. But I think you and ultimately the court can make it clear that what we're dealing with here is a situation that is utterly devoid of a factual basis. And the hypothetical that you proposed is not a situation that's utterly devoid of a factual basis. And in the context of a presidential election, and at one point somebody said, oh, well, one of the lawyers said, all they're doing here is trying to stay things for a while. Well, there are all these dates and they interlock, and eventually you have January 20th and you work back from that. So even temporarily interfering with those dates is a serious problem. And
Mr. Fox, I know we brought you to sanction, but I would just like to ask you one other question. What about the fact that the courts didn't see fit to take action and accuse Mr. Giuliani of filing a frivolous claims or frivolous acting with frivolity before the courts? What do we do with that situation?
Two responses to that. First, because of the safe harbors that are built into, I think it's Rule 11, there was no way that the opposing counsel could follow those procedures and ask for sanctions. That doesn't mean the courts can't do it sua sponte. I agree with you, but I want to make that point. The second point is that courts don't do it very often. And I don't think you can draw any conclusion from the fact that they didn't do it, particularly if you read what they said about the case that he brought, utterly devoid of factual basis.
But Mr. Fox,
I was just going to
say, what you're saying before about how there's absolutely no factual basis for this, we need to send a message, all the things that you just said so eloquently when you were talking about the sanction and why you wouldn't answer Mr. Walker's question. Why wouldn't that also, if it's so obvious, why wouldn't the judges have found that? You know what I mean? It doesn't, you can't have it both ways where the judge is going to, where it's so obvious on one hand, but on the other hand, the judges didn't do anything about it.
It's not in the record, but I have seen somewhere a survey of the number of times that judges sua sponte sanction lawyers for
But
bringing
Mr.
frivolous
Fox,
cases.
sorry to interrupt you, but I have the same question as Mr. Hora. I don't think, if your argument here before us is today is that this was such extreme behavior going to the core of our democracy, therefore he should lose his license. No prior statistics on how often judges raise frivolity. I think you need to answer Mr. Hora's question. Like, if this was as egregious as you're telling us it is here today, that it's going to the essence of our democracy, why would not the judges have taken the same position then and find him to engaging in frivolity before them and taking the actions that they're authorized to take as
Okay, last word got cut off, but I think I have your point, and I think it's a fair point. But and I guess what I would say to all of that is that I can't read the judges' minds. All I can tell you is that judges rarely do this, and that there's no requirement under the rules that the judge have sanctioned the lawyer. The judges certainly found a complete absence of any factual basis for the case that Mr. Giuliani brought. So I'm out of time. I'll answer any questions if you want, and or I'll take 10 seconds to just get out of this. Mr. Hora.
Hora.
Yeah, I guess my question goes back to the beginning, is what sort of level of knowledge about all the facts did you expect him to have, the day after the election or a couple of days after the election, such that we can sort of attribute the argument about how frivolous this is at the point when he's actually making the arguments that he's making, and without the lack of discovery and all that stuff. So I just want to, I guess I'm trying to figure out what do you think he should have known at the time that he became engaged in this case? And I know that's a matter of dispute as well, but whatever it might be, what level of knowledge did you expect him to have?
Yeah, I don't think there's any dispute that he started the case up on the 4th of November, but
I was talking about more about the first complaint versus the second complaint.
Oh, okay.
Yeah.
I can't quantify it because it's not a quantifiable thing, but he had to have something. I mean, remember, he argued fraud, and fraud has to be pled with specificity. And it's not that he didn't plead it with specificity. He didn't have any facts. I mean, all I can tell you is there were 26 facts that were spread through the complaints. We went through every single one of them in our proposed findings of fact to show how they didn't establish fraud, every single one of them. And nobody has ever contested that. I didn't bother to do it again for you all because it was cited by the hearing committee, and Mr. Giuliani has never contested it. He wrote a letter to us. It's in I actually do have the exhibit number for you somewhere, but it's Exhibit 32, our Exhibit 32. When we start these proceedings, we always start them by writing a letter to the respondent, and the respondent response. And Mr. Giuliani wrote us a detailed letter. It's Exhibit 32. I went through every single, and he laid out what he thought were the facts that supported the position he did. I went through every single one of them, tediously so, in cross-examination of Mr. Giuliani, and none of them held up. And you don't hear his lawyers citing any of those facts in that letter, any of those facts in the complaint, to say that he had a factual basis for the claims that he was bringing and for the arguments that he was making. So I can't give you a quantity, but you got to have something. You got to have something that gets past the Iqbal and Twombly standards. You got to have something that gets past, I think it's Rule 9, that requires you to plead fraud with specificity. And he had nothing. And this was done in the context in which it was done. A serious a bit of litigation that you could file something that's trying to overturn a presidential election, and he had nothing.
But I think that, in Spikes is what we're looking at here as the standard, right? And the standard is that there's not even a faint hope of success on the legal merits of the action being considered, right?
That's the standard that everybody agrees should be applied.
Right. And your argument is that there is absolutely no faint hope, even if there was this notice and cure element that was not deemed frivolous, that there wasn't this faint hope of success on the merits.
Well, yes, that is my point, and maybe I should spend a moment on notice and cure if you want me to do so.
I think that's important because to me it seems like that is, Mr. Giuliani's strongest argument, and certainly there's some merit to it, and there's some support in the case law, such that they're meeting the standard on In Spikes might be difficult for you, in that with respect to that issue.
All right, I don't think there is standard in the case law because what I think what you're saying there is probably Bush v. Gore. Okay.
Yes.
Remember, the first thing the court says one of the first things the court says in Bush v. Gore, and I'm going to quote it: "Our consideration is limited to the present circumstances for the problem of equal protection in election processes." Sorry, let me try that again because
Yeah, but Mr. Fox, you have to put this into the context of the standard that you're trying to argue here, which is a faint hope of success. If you're arguing that Bush v. Gore is limited to the facts that were presented in that case, that's fine, but it's still relevant to the inquiry of hope.
Okay, well, let's go to I won't parse Bush v. Gore with you, although I'd love to do so. But let's remember how this came about. There was a case that was decided in September, Democratic Party versus, I never have known how to pronounce this lady's name, Boockvar, I think it is, the Secretary of State of Pennsylvania, which established that the county's boards were not required to have notice and cure. After that, the Secretary of State put out publicly a notice that if you're not required to do it, but it's a good idea, and some counties did it and some counties didn't. Now, if you thought that that was unconstitutional under Bush v. Gore, which I don't think it is, but if you thought that, the thing to do would be to file an action, because this happened in September, would be to file an action seeking to enjoin the counties from doing that. Nobody did that. Nothing happened for the election. Now, so what happened? Two voters in counties that are not defendants in this case conceitedly filed incorrect ballots, and their ballots weren't counted. They had a grievance, perhaps, with the county boards that wouldn't count their ballots or didn't give them an opportunity to have notice and cure, but they didn't sue them. They sued 7 counties that provided notice and cure, and in each of the complaints there's a listing of the number of mail-in ballots in those counties, and the number floats around a little, but my county of it, you can do the math, is 1.3 million people. Voters who voted by mail-in, which is about half of all the voters in Pennsylvania voted by mail-in.
How does your argument that you're making right now with respect to the sort of precedents from Pennsylvania? I think it's Pierce v. Allegheny County, where they found an equal protection violation there with respect to absentee ballots.
That's not what they found. Pierce v. Allegheny County was what the court did in that case, and it was a district court opinion, was never reviewed. What the district court did in that case was it required the segregation of 937 ballots that were these were absentee ballots. This is before we had mail-in ballots. It's 20 years before. They segregated 937 absentee ballots because Allegheny County had allowed absentee ballots to be delivered by third parties, and Philadelphia County had not. And so they decided that could be a violation of Pennsylvania law, and that could raise Bush v. Gore type allegations. And so they entered a temporary restraining order and then refused to decide the case, exercised Pullman abstention, and allowed the Pennsylvania courts to resolve the issue as to whether that was consistent with the voting law in Pennsylvania.
But again, you're getting into into the weeds of the case, and that's fine. I mean, that's you know the case better than I do. You win. But the point that I'm trying to make here is, if we're talking about In re Spikes and the standard of faint hope of success, why couldn't someone look at Pierce v. Allegheny County and think that there's a faint hope of success in making the arguments that Mr. Giuliani did in the lawsuit that's at issue?
And I'm going to add on to Mr. Hora's question, a faint hope of success when there's voting, absentee voting during a global pandemic, and then tying it back to Spikes, which says the law is not always clear, nor is it and it's not static, and prohibition of frivolous litigation should not chill zealous advocacy. And in this situation, we have inconsistencies between the counties on the notice and cure, and then we also have the observational barrier issues as well. So I'm asking the same question that Mr. Hora asked. I'm just adding a couple more items for you to consider and address.
Sure. And there are two things that I would say in response. In shorthand, remedy and numbers. The first is remedy. This is a 1983 action. 1983 was enacted in 1873 as a result of the Civil War amendments. 13th, 14th, and for our purposes, most important, the 15th Amendment, which was designed to expand the right to vote. This is an action brought under a statute that is designed to protect people's right to vote, that sought to disqualify 1.3 million legal votes filed in the state of Pennsylvania because two people had been denied a notice of cure. Who would possibly think that that kind of an action stood any kind of chance?
Well, but the two people can turn into thousands of people. You just need one person withstanding to start. I mean, when you're talking about a class action, right? Sometimes you got to go through that process to find out who else is out there that's been similarly affected. So I don't understand the basis of the two people and how many people you expected them to get at the time when they're trying to litigate this right after an election and up with a deadline, a hard deadline coming up only a few weeks later.
I'm coming to numbers in a second, but to follow up, my basic point is that if these people were deprived, and if other people were deprived, what civil rights statute gives you the authority to ask somebody to disqualify legal voters to remedy your deprivation? It doesn't make any sense. It would be, if you go back to the Jim Crow days, when in states had these tests that they made voters take that probably none of the lawyers in this room could, or in this hearing, could pass. And if one county in, let's say Fulton County comes to mind, if Fulton County imposed a stricter test than DeKalb County, could the voters who were deprived of voting in Fulton County say, well, the voters in DeKalb County should be deprived as well because we were deprived? No, it doesn't make sense.
I do think, Mr. Fox, you are mixing the what you believe or what you're ascribing the intent behind the lawsuit versus what they can actually get and who's going to agree with that and whether or not a judge is actually going to grant them what they're looking for, right? If the intent is to overturn an election, we can all agree that, whatever, actually, I don't even go there. The point is that you're ascribing the intent as to what they're trying to do with not what they actually can or would be able to get by a lawsuit that was filed. The judge is going to have to look at that and say, do I agree with this? Do I not agree with this? It doesn't really matter what they want. It matters what's available to them.
Mr. Fox, thank you. Ms. Blumenthal, do you have any questions for Mr. Fox? Ms. Cassidy, do you have any more questions for Mr. Fox? Mr. Walker, do you have any questions for Mr. Fox? Mr. Hindle, do you have any questions for Mr. Fox? Ms. Rice Hicks, any more questions? Mr. Tiger? I'm sorry, I skipped Mr. Gilbertson.
Nothing further, thank you.
Mr. Tiger? No? Okay, thank you so much,
All right.
counsel. And Mr. Leventhal, are you going to go first with the 3 minutes of rebuttal?
If I may, I'm sorry. I was
Yes,
muted.
yes, please do. Thank you.
Okay. All right. Firstly, Mr. Fox is making a cause célèbre that he's bringing partially state actions as part of the equal protection and due process. Equal protection and due process is a federal violation of the federal law, and under 28 USC section 1367, the federal court can exercise supplemental jurisdiction on the state claims. So really, that's a non-issue. I've cited also cases where state claims have been brought in federal court in supplemental jurisdiction. Regarding the equal protection, as one of the, I think it was, oh, I can't find him now on the screen. Mr. Hora, did I pronounce that correctly? Had brought up, there were other cases. There was also Chafaros equal protection. And I want to point out that Mr. Hicks actually was the attorney of record in the Allegheny Pierce versus Allegheny Board of Elections. So he was really the impetus behind that. And I'd like to take issue with what Mr. Fox said, that on November 4th he was drafting the complaint, because the ad hoc hearing committee found on paragraph 11 of their findings of fact that Mr. Giuliani started to work on litigation specific to Pennsylvania after receiving a phone call complaining about observational boundaries in Philadelphia. Now, when we talk about drafting the complaint, he did put in that he thought that there were similar problems of observational ballots throughout the country, and that was really his contribution. Now, when Mr. Fox says or that being in the room was sufficient, there was dissent on that in the Supreme Court, that was not a meaningful observation. So even though the Supreme Court said that was okay, there were dissents. Now, if there were dissents, then Mr. Giuliani's claim cannot be considered frivolous, because there were dissents that say that's not meaningful observation being in a room. These rooms were huge, huge. Now, Mercer was in the room, but the majority of the court said that's sufficient, but doesn't mean you could meaningfully observe. He was only charged with 3.1. That's what he was charged with. And I think that the members of the this Board of Professional Responsibility are in tune with that. I just want to point out to you, these laws were changed very, very quickly. Pennsylvania has a constitutional provision, which is in our brief. I think it's section 7, subdivision, subsection 14, which limits who can file an absentee ballot. Mr. Fox says, oh, we couldn't raise that. Well, a Supreme Court case just came out since the hearing, Moore versus Harper, where Judge Kavanaugh and the Supreme Court of the United States basically said that we have to monitor whether a state follows its own constitution. And somehow Pennsylvania was allowed to amend the Constitution by a legislative act, which I think was patently improper, but that's neither here nor there. That's why we raised it now, because this case came out after. And I just want to reiterate, comparing Mr. Giuliani to a convicted spy who spent 22 years in jail, and also to say that his service is forgotten. We have something in New York called the 9/11 Victims Compensation Fund. where people are still suffering from cancer. We still have widows and orphans who are being helped as a result of this 9/11 tragedy. I think it's really a disservice to these people to say that Mr. Giuliani's service should be thrown out and disregarded.
Thank you,
And-
Mr. Leventhal.
Okay.
Thank you. And we can hear from Mr. Kamens now for his rebuttal, unless there's
No,
questions. from anyone
I
on-
was gonna just talk about sanction as well. I figure it
Oh,
would be
okay.
easy-
All right.
easiest.
Are you gonna take his 3 minutes then?
Well, that we only need to take 3 minutes total.
Okay.
If you have any more questions, Mr. Kamens, I'm gonna let him answer them because he is the resident expert on sanction. But I just want to point out that everything is not so clear. There were dissents on some of these cases. And I just have to say that he could have, the complaint could have been better. Knowing now what I know, I would have sued all the counties. And that definitely wouldn't have been a frivolous lawsuit. Because then you would be able to determine how many ballots were cured, how many ballots were not able to be cured, and then we could see if that was a fit. Now, if he doesn't know that amount, are you going to hold him to that? Even when he brought that lawsuit, he'd have to figure that out. We didn't know those figures.
Okay,
So
thank you, Mr. Leventhal. Your 3 minutes are up, unless
Thank you,
members of the
and
board
thank
have-
you.
Mr. Kamens?
I think that Mr. Leventhal covered the points we wanted to make on sanctions.
Okay, all right, so we're all ahead of the game by 3 minutes. All right, council, thank you very much, and we will take this under advisement.
Thank you very much.